listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Thankful I am, Kyla,
Why?
to be with you because life is frail and we get these rare opportunities to spend time together doing the podcast. I don't see you very often these days because you're
I've been in back-to-back
back-to-back
trials all day, and then my car broke down while I was coming back from court and got stranded in small town BC.
It's been
Been a week.
a week of lots of stuff and
But I
ups and downs
After we
too.
did the podcast, I was also we were drinking off camera because
Because
we
it had
had
been
rough week.
but it was later in the day, so we could justify drinking. This time of the day,
I still have court.
no drinking.
More
Yeah.
court for me. So
So
So let's talk about Pat King.
sure.
Remember him?
Yep.
Freedom Convoy organizer Pat King.
I thought we'd be talking about the changes to M driver thing.
Yeah.
Okay,
So
well, we could talk about that later. Anyway,
we will. I actually hadn't planned that as a topic, but that works.
it's a good one. I haven't had a chance to talk about the topics like this week, folks.
So Crown appealed.
Yes.
He was convicted of a number of offenses at trial. He was given a CSO, and he was also convicted or acquitted rather of one offense, which was trying to remember. It matters for this story, but
It is the topic.
intimidation of a justice system participant, I think, or intimidation generally. Anyway, he was convicted of that or acquitted of that, and the Crown appealed. And on appeal, they canceled the acquittal and substituted a conviction and sent him back to the judge to be sentenced again.
How is this driving law again, aside from convoy?
Because it was the charges that arose out of his Freedom Convoy.
Yeah, okay.
Yeah, this was all
we did
part of
this.
that.
We did frame it
Oh.
as driving law at the time.
Don't you remember the whole gridlock in downtown Ottawa, the honking, and the 3-week occupation of our nation's capital? Has that all been lost on you?
Active forgetting. Active forgetting.
Forget.
I believe in active forgetting. You know that. Move on.
Yeah.
Nothing's perfect in this workaday world.
So there was the intimidation charge. The court he'd originally been acquitted because in the offense under Section 423 of the Criminal Code, it's not just enough to be threatening, but the judge basically interpreted it that. So the crime is to wrongfully and without lawful authority compel another person to abstain from doing something they have a lawful right to do or something they have a lawful right not to do by any of specified means, one of which was violence or threats, persistently following someone, watching, besetting a place, or, importantly, and the driving law component, blocking or obstructing a highway. So that's where the intimidation came from, was this, he was charged because he was blocking or obstructing a highway and encouraging people to do it, the actual act of the convoy.
Your driving aspect.
Yes. And he was acquitted because the judge imported into it a threatening requirement, which was not something that actually exists in the criminal code.
I'm surprised more people aren't charged with that because you see even the brake checking context could
be
characterized that way.
Yes. Now, you might be thinking, Paul, what about his charter rights? What about the fact that the offense itself also arises out of him exercising his protest rights?
Well, you know about how I feel about the charter.
You like the charter.
I know, and I like to refer to it as le charter.
Thank you for your insightful comment there. So the trial judge had also addressed the charter issue and said, look, the protest was regardless of how it was done, it was nevertheless a political protest, and it was a protected activity under the charter. And so the protected character of the protest, the charter protected character of it, was a reason to keep the intimidation section away from the reaching the convoy's conduct, which is funny because that intimidation section about blocking highways was specifically added to the criminal code to deal with protests that blocked highways.
Yeah, it was after the blockage of railway lines. It
Yeah.
was added for that purpose to prohibit the blocking of highways or railway lines or anything along that line that was essentially public transport.
Yeah. So the Court of Appeal basically says there's a legal error, that the protest didn't require there to be actual violence or threats of violence. It was enough if it wrongfully blocked the highway. And in terms of this, charter protected angle, the court said no. Even though the protest arose out of lawful conduct, right? Like you can go march through the streets of downtown Ottawa, and if you want to beset upon them for a little while to make your point clear, you can do that. You can't do it for 3 weeks. Basically, it turned into a coordinated, targeted, this is the line, coordinated, targeted attack on Ottawa residents aimed at coercing change through highly disruptive criminal conduct. And that the purpose of the continued occupation was to use the pressure exerted on ordinary residents as leverage to force the government of Canada to change their position on the COVID-19 policies that it was lawfully entitled to pursue, and that therefore the wrongfully and without lawful authority requirement was met.
Yeah, and I think that this is the court recognizing that people who protest are going to come up with new and different ways to protest, and some of the ways are not going to be acceptable. Bearing in mind that not every criminal act is excused by virtue of the fact that you got freedom of speech to protest.
Yeah. But, I mean, no new trial, though, right? Like, he doesn't get
Sent
any
right back
trial.
for a conviction because the facts were all in,
Yeah.
and it was an application at the end.
It was just the legal
But
standard was
for
incorrectly applied.
Yeah, but for the charge being thrown out on the charter argument, it would have been a conviction, so just make it a conviction.
Yeah, and so then they didn't even have to deal with Crown's argument that the sentence was too lenient because now there's another offense to be added to the offenses for which he's sentenced, so he just gets a brand new sentencing.
Okay.
Bippity boppity boo.
Yep.
Bob's your uncle, and Pat King's probably going to end up in jail.
Did he serve jail last time or did he
No,
get
he had
CSO?
no.
Yeah. So he might get another CSO. Might get more CSO.
It seems unlikely.
Unlikely that he'll get more CSO.
I think he will not get a CSO. But we'll see.
90 days in jail.
Time will tell. Yeah, probably. Anyway, there you go. So, ICBC changes, what you wanted to talk about.
Well, I want you to inform me all about it because you wrote about it.
Oh. You think I remember anything I wrote? I don't even remember the last sentence I wrote before we started recording this podcast. It's been so busy.
I know. So the provincial government announced some time ago that by spring, which was a couple months ago, they would have these changes implemented where you no longer had to go in for a test to get rid of your Class 7 N license. It would automatically be converted to a Class 5 license, and the rules and the mechanism was going to make it happen.
When government announces that they're going to do something by spring, what they mean is they're going to re-announce it in spring, finally implement the legislation in summer, to have it take force and effect in fall.
Well,
You should
actually,
know
there's
government
another
time.
good example of that, and that is the provincial governments in this country said by May of this year, so a few months back, they were going to have the rules dealt with respect to interprovincial sales of alcohol. In other words, we cannot sell a bottle of our alcohol to somebody in Calgary. Can't do it. You can come to BC, have some Nookum gin at a wedding, and it's wonderful, and you'd like to have some, and you contact our distillery, and we have to tell you that it's illegal. They said they were going to have that resolved by May, and now, right now, like as of yesterday and 2 days ago, meeting in Charlottetown of the premiers, prime minister there, federal government has done all sorts of things to eliminate these barriers. The BNA Act says there shall be no barriers, and the provincial governments haven't done anything. Now they're saying by the end of February, they're going to have it in place, all but Quebec, which won't agree. No surprise there. So exact example of the same point that you're making.
Government timeline, yeah. Anyway, so basically the changes, as of October 19th, 2026, people who have their Class 7, or 7-8, so your motorcycle, um, license and a clean driving record will not have to take the second road test, and they can graduate to a restricted Class 5 license.
So a new Class 5, a
But
Class 5 with restrictions on it, what we used to call a probationary license
it's
in
your
Alberta.
it's kind of funny to me because the restricted Class 5 license is really just the N without the decal and the passenger restriction.
And I can understand that. I was thinking about that. I see what you're saying. You're a little bit cynical about it because really what they're not doing is they're extending it. You're getting your Class 5. So
Yeah,
at
you're
least
getting
if you
3
lose
years of monitoring.
something goes wrong, you're not still stuck in the Class 7 loop for forever if you get into trouble. So there's that, that's good. But you're still under many of the same restrictions you have as a novice license in BC, except you can have more people in your car and you don't have to display the highly stigmatizing N on the back of your car. We see people hiding it behind their license plates and hiding their N, putting it on the side of their car, all sorts of different things because they're like embarrassed to have an N.
Yeah.
I kind of get it.
Anyway, so the changes depend on a number of things, like what's actually going to happen. So there's a driving record assessment that will happen. So instead of when you're eligible, your first eligible date for your road test, which is printed on your license, if you have an NRL license and you're looking, you can actually see that on your license. That date is going to trigger a driving record assessment. Do you think that driving record assessment is going to automatically happen on that date?
Gee, I think it's gonna be a computer that just looks at it.
I think
It's
there's
not
going to be
gonna be somebody who look at
letters
it.
going out, and then you'll be able to upgrade to a Class 5 or 6, once you meet all of the criteria. So number 1, 24 months of safe driving, or 18 months if you did a graduated license program approved course while you had your L. It's like BC Safe, not BC Safe Driving, sorry. The what's the name of the course? Young Drivers of Canada course?
I don't know. I looked
Yeah.
this up for my teen, and I couldn't find what's an approved one.
So that's if you are um under 25. So for anyone under 25, it's 2 years of safe driving before you can do that, or 18 months if you took the course.
More official age discrimination.
But if you did not complete an approved course, you'll have to do the 24. And if you're 25 or older, you actually only have to have 12 months of safe driving. So if you're one of those people that decided not to get a driver's license back in the day, and all of a sudden you realize, oh shoot, now I'm 32 and without a driver's license. What kind of mistakes have I made in my life that got me to this point? I'm not saying this because of previous romantic partners of mine were all non-drivers in their 30s.
You dated some real winners.
I did. Uh, it was really annoying chauffeuring them around. Um, and anyway, the point being that if you realize your life was misspent, you'll only have to spend 12 months with your N instead of 24. And then you can get your restricted Class 5. But also, Paul, you cannot do it if you have had a conviction for excessive speed or use of an electronic device or any other prohibitions or suspensions, which actually makes it harsher than it currently is when you're in your 12 or 24-month graduated license program end period. Because right now, you get an excessive or you get an electronic device ticket, it's an automatic driving prohibition. You're going to lose your license. So that's a problem for you. But if you get a 24-hour prohibition, an IRP, technically under the way the Motor Vehicle Act regulations are written, those do not count as prohibitions for the purposes of resetting the end clock.
Okay.
So,
Cell phone ticket is a big nightmare scenario. And 2 days ago, I was on 4th. I looked over a young guy in a 20-year-old BMW with an N. There he is with his cell phone in his hand. And I would love to just warn him. I mean, aside from the fact that I'm not enthusiastic about the fact that I see so many people violating the law in that regard, you just want to warn them, don't do it.
yep. The other thing that is
Just ignore that.
it's a phone. The other thing that's changing. Oh my God.
Yeah.
uh, the other thing that's changing is now this year after. So I assume, and they don't actually like articulate what's going to happen in this restricted class 5, but I assume that it's going to be the same thing. It's going to be that you have no convictions for excessive, no electronic device tickets, no prohibitions or suspensions. Otherwise, you can't graduate from a restricted class 5 to a full class 5.
Well, and you're probably also facing the same driving prohibition you would get in those circumstances. The only thing is at least you've got your class 5, so you don't have to worry about having a impending class 5 consideration coming up as a class 7. So there is some value to that. But
Yeah.
at the same time, it's like you get your class 5, you're 11 months into having your class 5, you end up with a conviction for something, or you get pulled over and you get charged and you end up with a conviction 9 months later for something, then you're facing that driving prohibition. So there will be, and people won't necessarily consider that. They'll think to themselves, I've got a class 5. So there's going to end up with a bunch of people who end up prohibited
Yes.
from driving who would not have factored that in when they paid that ticket or made the decision about how to deal with it.
So the lesson is dispute every ticket you get, as we've been saying for years and years.
Feels very self-serving because we defend tickets,
You
but
don't have to hire us to deal with your tickets.
there's other lawyers too.
Hire someone else if
Yeah.
you really want.
Yeah. I don't
I'm
know
just
why
saying-
you would, but
Just saying, dispute every ticket. Like, all right. Should we turn to?
The ridiculous driver of the week.
you sent it to me. It was a pretty good one.
Yeah. So, I actually was, we ended up talking about this on Soapbox Social yesterday on CBC.
I sent it to Mike Smith because I thought we should really talk about an issue that is rarely discussed in this province because we are friends and neighbors with our friend
Alberta.
in Alberta. But
I don't think we can be friends with Alberta anymore until they stop their secession.
I've got some problems with Alberta, and I live there I'm born and raised Albertan. That's how I'm Prairie Paul. I lived there until I was 30. I got my education there. I had family there, and I got some real problem with some Alberta drivers when they come to BC.
Like this guy.
Yes.
So he was in, where was he? Like Elkford, Fernie area, I think. Come on. Oh, Cranbrook? I don't know. Anyway,
Similar area.
somewhere around the East Kootenays, Columbia Valley area. He was observed by a police officer speeding 230 kilometers an hour
In an 80s
in
zone.
an 80 zone.
In a
an-
Mercedes or something
An
like
Audi. It was an Audi. Yeah. 230 in an 80 zone near, Fairmont Hot Springs. That's where.
Yeah.
And so the police, obviously, in that circumstance, they can't conduct a traffic stop.
No.
It would be a pursuit. There's no way. Like, you're at 230 kilometers an hour. You're not glancing in your rearview mirror to see police lights because you're going too fast that if you take your eyes off the road for that long, you're going to crash.
So did they radio ahead or what did they do?
They got information, I guess. They believed, based on something, that the vehicle went to a particular campground. I don't know if maybe they had information about a reservation that they were able to look up or whether they saw it turning down a
Somebody else
road.
may have noticed it. Some other officer, some off-duty officer.
Who knows? Anyway, they converge on this campground, and they speak to members of the public who are at the campground, who are all very willing to cooperate with police and roll over on the 230 kilometer an hour guy. And so they locate the vehicle parked and empty. Your spidey senses are tingling here.
Mm.
Parked and empty before they tracked down the driver, and then they formed suspicion that he had alcohol in his body, made an ESD demand, and he got a warrant reading.
So he got a warrant reading. They issued him an IRP of 3 days. So they towed the vehicle. They ticket him for excessive speeding as well. Whether or not they ticket him as the owner or a registered owner or as the driver.
Oh, he had no DL as well.
Oh, no deal. Okay. All right. So plenty of things. That car's gone for at least 7 days, and an excessive speeding ticket in BC at the higher tier,
Mm-hmm.
and everything they could possibly hit him with. Which brings me back to the old Alberta drivers, and I don't want to fan the flames of.
Well, hold on. There's one more thing they'll hit him with.
Go.
they hit him with a referral to the Alberta, Safe Roads Alberta, because they review driving sanctions, and so they did basically the Alberta equivalent of a high-risk driving incident report. Dude. I know. Like, ordinarily, I'd be like, "Isn't that overkill?" But 230 is just, like, a reprehensible speed.
No, I mean, that's fine on the Autobahn and
Wonderful.
the spaces where it's safe to do it. I don't like it. I think it's too fast, but that's Autobahn speeds. There's nowhere in Canada where you can even come close to safely driving that speed. And he certainly could have been charged with dangerous operation of a motor vehicle with speeds like that.
Why are they not geofencing cars so that they can't go that fast? Like,
Well,
that should be required by Transport Canada.
they actually are in Japan.
Yeah, I know.
So I'm surprised that we permit it. And I've mentioned this a few times, and I can tell you, the ire of the people who are in that high performance car market, very upset about even the discussion about it. But yeah, there is a problem that we've seen develop and become worse over the last 20 years, and that is people from Alberta coming to BC and thinking that they can just disregard the rules of the road when they cross the provincial border.
Yep.
And it is, if you talk to people in the Okanagan, it is just like such a common complaint of Alberta drivers, guys coming in their Dodge trucks and rolling coal. People just driving like complete jerks when they come to BC on vacation. BC is great to visit on vacation. There's almost no mosquitoes. I'm sorry to even tell you people that from central Alberta, where you've been dealing with this basically great flood. There's almost no mosquitoes in much of the area. The weather is like temperate and beautiful, 23 degrees in Vancouver today. And it's a lovely place to be. But if you're going to come to BC, please abide by the law.
But I do want to say, though, like, the IRP to me seems questionable. They didn't locate him driving. It's unclear to me how they actually determined he was the driver.
You can see lots of defenses there. And
Yeah.
if you want to talk,
Post-driving
if you want to
consumption.
talk them out, we can
Yeah.
do that.
We don't have to. I've got a pretrial conference, and we're coming up on our time for our podcast
Yep.
already.
Yep. I'm just glad we had time to record a podcast. So I'm thankful about that. Last week, I did it with John Collins alone, and I think it was good. But, John is someone who you could just let talk, and I think I was talking too much. So I don't know if anybody listened to the podcast. I'd love to have
I haven't
something.
listened to it, but I can't.
Can't possibly imagine.
We could have just had 45 minutes of John Collins, like, entertainment hour. He's the funniest person.
When I get Grant Gockertro on when I'm doing these podcasts and you're not available, it's Grant and I both and neither one of us can shut up. And John, I should have just let him go because he is honestly the most.
What was it like,
person.
John, when you were a police officer and administered SFSTs? Like,
Back in the day.
his jokes about how he used to deal with people, like, they're so funny. So funny.
I've learned a lot from him over the years. One of the things that we talked about last week was when the prosecution offers you something stupid and you're sitting there thinking to yourself, well, that's no better than I'd get if I ran a trial. And then you go to run a trial. And as John has described it, and you've heard this before when he's been teaching us, a trial is like a police officer testifying is like a three-legged stool. All you have to do is kick out one leg. And so if they fail to comply with procedure, that could be the leg. If their memory is faulty on something, that could be the leg. There's just there's always an opportunity there when you run a trial, and there's no opportunity if you plead somebody guilty. So
Yeah, I will say too, like, in terms of running trials, one thing that you also have if you run a trial is shit happens.
yeah,
Like, you might have no defenses, but you don't know the court time's not going to be overbooked. You don't know that some witness isn't going to say something crazy on the stand. Some piece of evidence you didn't know existed suddenly comes up. Like, the number of times I've been running trials just because I have nothing else, and I'm not pleading my client for the minimums because he's going to get the minimums after trial, and then something appears.
how many times is some crucial piece of evidence that the police are supposed to have with them, nobody can find it? It's not in an evidence locker. It's nowhere. They can't find it. They don't know where it is. And you're like, other times you're running evidence continuity arguments, and everybody just wants to skip over it because they don't think it's meaningful. But so often there's these things that happen. Police officers can't find any of their notes. Police officers show up, they can't remember anything.
I remember one.
They're so tired because they work 3 nights of shift, and we had one last year where the police officer was like, I don't really feel like I should come back here. Like, I've got work to do.
Oh,
Like,
yeah.
this is work. This is
This is your
job.
Yeah. I had one once where I had nothing, and it was like it was maybe like, I think this person had many priors for the same offense, and there was a flood at the RCMP detachment, and the original certificate got destroyed.
Yep.
Like, thank you for the divine intervention. Made a deal.
Yeah. I tell my clients, and I don't wish to be mean about it, I tell my clients, you never know. I mean,
Yep.
a police officer could get hit by a bus. Well, you say it probably because you heard me say it back when you were in your training, back when you were, I was the master, and you were the trainer, and now you're the master. I don't know that I should say that to people, but I have had, we've seen police officers who were injured.
Yep.
And can't come to court. And you're like, did you plead your client guilty on Monday and the trial was set for Friday, and the police officer or something happened to them on Wednesday?
Yep.
So unless there's something that's worthwhile, you're not pleading your client out.
All right. Well, then, with that, on that, that's our podcast. And if you have a driving law-related issue, you got an excessive speeding ticket, a 3-day IRP, or anything like that, you can give us a call at 604-685-8889 or find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Grabbing Law.
We even defend Albertans.